A lot has happened in Massachusetts. We have much to catch up on, and we are going to go through what happened in the hearing I thought we were going to be covering this week, which was the hearing that they set as a status hearing on Zoom. And then I thought we were just going to cover whatever filings there were because we knew there were going to be a bunch of motions to compel. I don't know why there was an emergency hearing put on calendar. We're going to go through those docket items together. We're going to go to the emergency hearing, and then we are going to go to court in Massachusetts. We're going back in time to June 26th for this hearing. It was a Zoom hearing.
Do you have Mr. McCabe's deposition later this morning?
No, Your Honor. This is Attorney Rosenberg for Ms. Reed. That's the subject of the pending motion to compel that's going to be filed imminently. Earlier this week, Ms. Reed sat for a full day of deposition noticed by the plaintiffs. Yesterday, we had the deposition of Michael Proctor pursuant to your order on the motion for protective order. Mr. Proctor appeared. The deposition began about 2.5 hours late at his request. But we
Tell me Proctor's running on EDB time. What do you mean?
He did begin at roughly 12:30 and ended at 5 o'clock again at his request.
That's a short day.
But we were able to get started. That's from my end, the most recent update.
So you're not done with Proctor's depo?
What other depositions have taken place?
Your Honor, Attorney Buck, on behalf of the plaintiffs also took testimony of Caitlin Boudreau, Miss Reed's sister-in-law, on the 17th of June. That went forward as scheduled.
And what, if anything, did you discover at that deposition from Karen Reed's sister-in-law?
I departed the deposition early to appear in front of Your Honor, but I believe it concluded. I can confirm Attorney Rosenberg accurately stated that we took testimony from Miss Reed on Wednesday of this week. We adjourned by agreement at the end of the deposition, and will work on securing a second date to continue that testimony in the near future.
Any other depositions?
No, Your Honor. I think the other ones that you were aware of from our end are all subject to motions to compel, including.
Oh, boy. So all of the other depots, he says, are subject to motions to compel. And we have a new motion to compel that we have not covered. And it is for both the Alberts, both the McCabes and Higgins. And then there's a pending one for Colin Albert. And then Tully is trying to quash his subpoena.
The Colin Albert and Brian Tully, which is the motion I had flagged for Your Honor at our last appearance in person, which is now filed and docketed.
Since our last status, Miss Reed's counsel did take testimony from Allie McCabe.
Correct.
Okay.
Thank you, Mr. Bond.
So one thing got done.
Attorney Daly, what depositions do you have on the list here?
Probably not
Your
very
Honor,
many.
we have Michael Camerano and Caitlin Albert, who are patrons of the bar. We also have a forensic scientist from the state police, Nicholas Roberts, on our list.
And that's for the
on
bar.
July 10th?
Yes, Your Honor.
Remember, the court also asked them for a list of the depositions. So the court has a list, presumably in front of him, because it looks like the court is looking at the list they gave him. So they have the list, and now the court is looking at the list and asking them, what else do we have?
Okay. And on behalf of your client, Attorney St. George?
Good morning, Your Honor. I understand that representatives from my clients are going forward later this month. And I do not know what other depositions are going forward later. That's the only ones I'm aware of at the moment.
Your Honor, if I could step in here, we've been kind of coordinating depositions with CF McCarthy's. There are two additional patrons who are at the waterfall, Karina and Nicholas Kolakithis. Those
Leave the Kolakithis alone.
are presently scheduled for July 29th. They had to get moved from the 15th At the request of the Cole-Keithises, they could not make it on July 15th, but we're expecting it to go forward on July 29th.
Okay. So the Cole-Keithis is July 29th.
Okay, sounds like we're trying, but we're not getting very far. So I guess,
Yeah, Your Honor. They're all subjects to motion to compel.
a lot's going to be determined through the motions to compel.
Uh-huh.
And there was one filed yesterday, and when are the other ones going to be filed, Attorney Rosenberg?
By Monday at the latest. We now have the opposition. If we can get them in today, we will, but I'm not sure because we've had 2 depositions all day the last couple of days. But we will get them to you by Monday at the latest. And that's only one remaining. It just relates to a number of defendants.
Okay, I guess I'll get them when I get them.
The plaintiff's motions will be circulated and filed early next week as well, Your Honor.
And what are those motions?
That would be the motion to compel Aidan Kearney and the plaintiff's motion to compel further answers of interrogatories from Ms. Reed.
So that's the end of the June 26th hearing. And with that hearing, we heard just a very few things. One, most things are now subject to a motion to compel, either from the Reed side or from the plaintiffs. The plaintiffs have motions to compel out for Aidan Kearney and for further answers to interrogatories, which are sworn question and answers. So, hey, question. And then you have to give a sworn answer. With regard to the Aidan Kearney, when the court was asking when did the 9A deadline pass, that's because Massachusetts has this process of motion filing that we've talked about in the past, where a party serves a motion on the opposing party, then the opposing party answers or opposes that motion, then there's a reply, and then all of those, motion, opposition, reply, those go to the judge together. But if the 9A period passes from, hey, I serve this motion on you, you have this window of time to oppose the motion. If it's not opposed, then the motion gets filed with the court without that answer from the other side, without that opposition. So the motion to compel with regard to Aidan Kearney was filed after the 9A period closed. And so it was filed as just the motion, no opposition, no reply, because if there's no opposition, there's nothing to reply to. So just a motion to compel. Then we have the plaintiff's motion to compel further answers to interrogatories to Karen Reed. But we also now have Reed's motion to compel answers and depositions from McCabe's, Albert's, Higgins. And then we have the Tully group of motions where Tully is trying to quash subpoena for his deposition and answers, and they've opposed, etc. So it seems that basically everything of substance in this case is left to motion work. And we are going to take a look at briefly some of that motion work before we get to the emergency hearing. This was a status hearing. The court has been very much like, I want to get in everybody's business. What are we doing? Are things moving along? But then it seems to me when things are not moving along, the judge is hesitant to actually push them along. He just gets into hearings and is like, okay, well, we're going to need another hearing and we're going to need more information. And so things are not actually moving along. With that, let's take a look at a few of these filings so we have some kind of an idea about how, well, I hope we have an idea about how we ended up in court yesterday. We're going to take a look at the court's order with regard to Karen Reed's motion to compel the deposition of Colin Albert. We saw the court talk about it in multiple times in hearings, and I'm surprised actually that there was an order because I thought that the court was waiting for more information from the defense, but it seems that the court was just like, we're going to order. So this was from June 26th, Friday, on this order. We're going to take a look at that right now. Order relative to motion to compel Colin Albert to attend deposition and produce documents. 1, the motion to compel Colin Albert to attend a deposition is denied without prejudice, subject to receipt of further information as to availability from his counsel. We go to hearings. You yell at everybody. You tell everybody that the subpoena is still operable and you've got to make your client available for a deposition. And then we get to the very end of the thing and you're like, well, we need more information. The motion to compel Colin Albert to produce responsive documents is allowed as follows. Mr. Albert shall produce responsive documents communications for the period of January 28th, 2022 through June 18th, 2025. Oh, that's a longer period than I anticipated. Or represent through counsel that none exist. To or from Karen Reed, John O'Keefe, Michael Proctor, Courtney Elberg, Carrie Roberts, Chris Albert, Julie Albert, Brian Higgins, Brian Albert, Nicole Albert, Matt McCabe, Jen McCabe, Allie McCabe, Brian Albert, or Yuri Buchanan, which relate to the circumstances of the death of John O'Keefe, any law enforcement investigation of Mr. O'Keefe's death, and the plan alleged by Ms. Reed of Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins to exonerate themselves and implicate Ms. Reed in the death of Mr. O'Keefe. That's annoyingly narrow. So this is narrow in the way that Colin Albert's attorney was arguing for. They got more of what they wanted, not all, because it's broader in time than what Colin Albert's lawyer asked for. But I don't think that matters because it's narrow in scope. It's not quite as narrow in scope as they had hoped for, but this is more in line with what Colin Albert's attorneys were asking for than in line with what Karen Reed's attorneys were asking for. Both sides are going to just argue more about what the plan alleged by Ms. Reed even includes. Because I think that that language still leaves a lot of room for lawyers to argue. And there is going to be argument over, okay, well, this motion is denied without prejudice, so they have to go through a whole new month of a motion period. This is going to continue to be a mess. On June 29th, we got another order from the court. And this order is related to the emergency hearing that we're going to cover. Order relative to order of impoundment endorsement on paper number 112. I have been advised of information that allows for a reasonable inference of a violation of an order of impoundment issued by me. It is hereby ordered that 1. Each plaintiff and defendant and each counsel with notice of appearance in this matter. Oh, that's a lot of people. Because so many attorneys have notice of appearance on this case so that they can appear and stand in for the different hearings. But it's notice of appearance as of June 8th. Shall file with the clerk on or before 4:30 p.m. on Tuesday, June 30th. So the court gave them like less than a day. A certification under the pains and penalties of perjury as to all facts known to them, as to any dissemination to anyone other than parties and counsel in this matter of any of the contents of the material impounded by order issued June 8th, 2026, order of impoundment. An in-person hearing is scheduled for Wednesday, July 1st at 3 p.m. So he posts this on June 29th and is like, y'all are going to be here in person on Wednesday. All counsel with a notice of appearance shall attend. All further attempts to take discovery from the party whose information was the subject of the order of impoundment is precluded pending further actions of the court. Oh, shit. Oh, the court's big mad. We're going to just take a look at the docket real quick together so I can show you guys what the court is talking about in this docketing. Docket 112 is right here. You can see that there's nothing there. It's impounded. Other interested party, Michael Proctor's motion to impound affidavits and supporting material. This is the day that the court was doing hearings all day and was like, what's going on with Michael Proctor going to his deposition or not going to do his deposition? And then they had to file stuff by like Sunday because Proctor filed his motion on Friday. And then they came into the hearing in the morning. And then the court was like, go back and get me more information. And then they came back in the afternoon and the court was like, well, we're impounding that information. But it was all of the Proctor delay of depo. So 112 was the order to seal Proctor's presumably medical information. I don't know if they're medical records. I don't know if it's just a declaration from a treatment provider, but medically related stuff. So the court said, any further attempts to take discovery from the party whose information was the subject of the order of impoundment is precluded. The court in this order, June 29th, has frozen all further discovery attempts from Proctor. Because we know that that's about Proctor. How do we know it's about Proctor? Because the docket says, docket 112, title, other interested party Michael Proctor's motion to impound affidavits and supporting materials. We are going to go to the hearing from yesterday.
I scheduled today to be in person because of the significance of what I was advised of last Friday, and because I find the quiet solemnity of the courtroom is a good reminder of the dignity by which courts are supposed to function. One commenter describes how every high-profile case now unfolds in two arenas, one governed by procedure and precedent, and the other by pixels, edits, and algorithms.
No, Your Honor. The commentator that matters says that courts now play out in two forms, the court of law and the court of public opinion. But I understand why you took the longer commentary on that.
And how the courtroom has become content and the law has become a spectacle. I recently held a hearing on a non-party motion for a protective order. I required the moving party to provide certain information. Such material was filed together with the motion to impound.
Can you tell me when the law has not been a spectacle? Like, didn't people used to just get put into the stocks and have like tomatoes thrown at them? And if we go back further, like burned at the stake, public executions, hangings, a fucking coliseum. Can we talk about when the law has never been a spectacle?
Such material was filed together with the motion to impound.
We saw.
A hearing that included the motion to impound was held on a Monday morning. I allowed the motion to impound during the hearing. The affidavits of the moving party and the attorneys were impounded. Following that morning hearing, I found that there was insufficient information to support a delay in the deposition of the non-party from going forward. However, I further found that given the claims made in the filings, I would delay making a final decision on the motion until later that day.
We watched.
To give the non-party's counsel the opportunity to supplement the record before me.
Right. You gave everybody multiple bites at the apple. It looks like the court wrote out what he wanted to say and is reading it.
I scheduled the matter for further hearing that afternoon at 4:15 with the expectation that there would be additional filings. At 2:22 p.m. that day, the non-party's attorney emailed the clerk of this court and all counsel of record, excepting one, additional materials in support of the motion for a protective order. The filing included a motion to impound additional materials. Exactly 30 minutes after the email to counsel of record of the additional material, which included sensitive and private medical information, similar information to what was in the exhibits to the filing and marked provisionally impounded, was posted to an X account at 2:52 p.m. Upon learning this information, I ordered that the parties and counsel provide a certification.
Well, when did you learn of it? Because we're talking about June 8th.
Upon learning this information, I ordered that the parties and counsel provide a certification to the court as to all facts known to them as to any dissemination to anyone other than parties and counsel in this matter of any of the contents of the material impounded on June 8, 2026, and I scheduled this appearance for today. I received certifications from all party and counsel.
Yeah, we saw
32 of
them.
them in total. No one apparently has disseminated, nor are they aware of any facts regarding the dissemination of the contents of impounded material to any person or entity other than the parties and counsel in this matter. However, somehow, an ex-account holder not part of this case, apparently received information that was at least provisionally impounded. Orders of the court.
It doesn't sound like someone posted the impounded documents, though.
However, somehow, an ex-account holder, not part of this case, apparently received information that was at least provisionally impounded.
Apparently received information that was provisionally impounded.
If these orders are to have any effect, all parties involved must operate with integrity.
What are you even talking
Rule
about?
13C of the Uniform Rules of Impoundment Procedure imposes a duty on all persons to protect the confidentiality of impounded material. Additionally, Rule 3.6 of the Rules of Professional Conduct prohibits lawyers from making extrajudicial statements that they know or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding. In case
Did you tell the lawyers what was said?
and will have a substantial likelihood of materially prejudicing an adjudicative proceeding.
We know that.
In cases like this, where all parties involved are aware of the public attention, I expect that everyone is taking every precaution to preserve confidential information, to follow the rules of the court, and to adhere to my orders. Because of the disclosure of sensitive private information, I temporarily stayed further discovery of the non-party. If necessary, I am fully prepared to make such order permanent
What?
as permitted by Rules 26 and 30. To any issue counsel may raise as to the management of discovery issues being within my discretion, I invite you to look at the following cases. In the 2000.
Oh, he is so mad because now he's getting on to how the lawyers are dealing with the way that he is handling discovery. But how do you violate a protective order in spirit? You either disseminate information that's impounded or you don't.
The malicious publication of private information concerns me. Whatever opinion that one may have of a non-party, even if warranted, such an opinion does not allow for the disparate treatment of such individuals. All people deserve fair and equal treatment in our system of justice, regardless of any personal characteristic, as abhorrent as some of them may be. What I am looking for is for the parties is adequate assurances that their discovery served justice and not any desire to weaponize the rules for pettiness and profit.
Have you been governing over this case yet?
If the parties and lawyers would enter into an agreement to hold private, personal information in confidence, and if the terms were acceptable to me, I would consider entering it as an order of the court so that any violation would be grounds for a contempt finding and appropriate sanction.
You have let these attorneys on all sides fight with each other, soliloquy, and continue to ramp up because you have not shut it down. And you want the attorneys to trust each other. When you have gamification like the yoinking of a deposition and then the setting of a deposition when somebody else wasn't available, and you have all of these instances of gamesmanship going on, and this is the thing, you want to yell at everybody about something that was posted on Twitter that you say is connected vaguely, and you want everybody to come to some sort of agreement that it would be grounds for sanction, and you're going to think that all of these attorneys are not going to weaponize that against one another? Because we've seen that already.
I would consider entering it as an order of the court so that any violation would be grounds for a contempt finding and appropriate sanction. including dismissal or default. Such an order would need to be more than a stipulation that deposition testimony can only be used for the purposes of this case. I encourage the attorneys to confer and to seek to reach an agreement. In the absence of an agreement, I will consider whether to enter an order based on my plenary authority to control, manage, and oversee the conduct of discovery. While you are conferring and seeking to reach an agreement, I will again remind you, as I have quite often, that the discovery clock is ticking. My final request.
No shit, the discovery clock is ticking. But when everything has to be done by motions to compel that take 4 hearings on a motion to compel to actually happen, of course, time keeps on slipping into the future. You spent an entire day when Proctor was supposed to be in deposition telling Proctor's team to go get more info. And then you said, oh, well, this wasn't good enough. Go to do your deposition tomorrow. And then it ended up being 2 weeks later.
I will consider whether to enter an order based on my plenary authority to control, manage, and oversee the conduct of discovery. While you are conferring and seeking to reach an agreement, I will again remind you, as I have quite often, that the discovery clock is ticking. My final request to counsel with an appearance in this matter is to familiarize yourself with Rule 3.6 of the Rules of Professional Conduct relative to publicity. The rule sets forth a basic general prohibition against a lawyer's making.
This is the second time he's said this in this hearing, and he has said this hearing after hearing after hearing. He keeps going back to the attorney rules on publicity.
As the comment to the rule notes, it is difficult to strike a balance between protecting the right to a fair trial and safeguarding the right of free expression. However, preserving the right to a fair trial for everyone necessarily entails some curtailment of information that may be disseminated prior to trial, especially where trial by jury is involved. If there were no such limits, the result would be the practical nullification of the protective effect of the rules of forensic decorum and the exclusionary rules of evidence.
What are the rules of forensic decorum?
Is involved. If there were no such limits, the result would be the practical nullification of the protective effect of the rules of forensic decorum and the exclusionary rules of evidence. The rule takes into consideration that the public has a legitimate interest in the conduct of judicial proceedings.
Correct.
Particularly in matters of general public concern.
Correct.
However, I'm not so sure that churning the waters to generate social media coverage necessarily can result in a legitimate interest in the conduct of judicial proceedings.
Whose algorithm is pissing you off?
Read the rule, especially if you have never done so. Adhere to it, or be ready to face the consequences for failing to do so. I remind counsel of what one commentator called the quiet expectation of fairness that we have as citizens. Such expectation is based on the framework the founders of our country built 250 years ago and trusted.
That's what it is. He wanted to be in the room where it happened. He wanted to be in the room where it happened, and he wasn't, and now he's mad.
Such expectation is based on the framework the founders of our country built 250 years ago and trusted future generations to maintain. Counsel, do your part to maintain the quiet expectation of fairness. Do not succumb to the attraction of seeking to influence this case through social media. Be what
I don't disagree with that. The filings and the way things are playing out in court is more of what I see as the problem.
Be what a trial lawyer should be, one that tries their case in the courtroom. And remember the provisions of General Laws, Chapter 221, Section 28, relative to the oath of office for an attorney in Massachusetts, which provides, in part, I solemnly swear that I will do no falsehood. I will delay no man for lucre or malice, but I will conduct myself in the office of an attorney within the courts according to the best of my knowledge and discretion, and with all good fidelity, as well to the courts as my clients. So help me God. I wish all of you a happy 4th of July on the anniversary of our America's 250-year-old democracy. May it continue to succeed with all of us working to maintain the rule of law. Thank you.
Court, all rise.
For the record, this matter is continued to July 10th, 2026 at 2 p.m. for hearing on motions to compel the criminal fourth session.
The judge called 250 lawyers into court with like 48 hours notice. And yes, I was being hyperbolic. It's like 30 something attorneys into court on July 1st with last minute notice to scold them about a supposed leak of former trooper Michael Proctor's sensitive medical information that was filed under seal. And the timeline the court cited in his pre-written monologue that he wanted to deliver to the lawyers and look them all in the face as he said it, in his monologue, was that former trooper Michael Proctor's lawyer sent out an email that had the declaration that we heard the court talk about at 4:15 on June 8th, and the provisional motion to seal and more supporting documentation that when they talked about it, it seemed to be medical records. And that seemed to also be the case today when the court spoke about it. And that was emailed after 2:20 in the afternoon. And then he says that 30 minutes later, there was a post on X. Somebody tweeted a something that seems to be similar information as to what was in the sealed documents. My question is, was that the same speculation that we have been seeing for weeks? Because there was speculation about former trooper Michael Proctor weeks and weeks and weeks before that June 8th hearing. So if all those things are related, and those rumors had been out there for weeks before we even get to this hearing, I don't know what thing the judge is relying on. And I can only hope that the judge gave the attorneys more information than we had. Because if I'm an attorney in this courtroom right now, I'm sitting there going, what the fuck? What was said? What are you referring to? Because lawyers want to deal with information. And if you show me the tweet or whatever the thing is that you think is the problem, then we can go figure out where the fuck it came from. But if nobody sees what the thing is, it just leads to more speculation. I'm concerned that he didn't show the attorneys anything more. I hope that he did. But when we have seen in other high-profile cases, issues and concerns about sealed documents, issues and concerns about sealed information, issues and concerns about people purporting to be jurors, we have always heard the judge say that they have provided that information to the attorneys and then they put something on the record. But he wanted this to be a public hearing and he wanted to tell everyone for the 17th time in this case, he doesn't want to see the attorneys making statements to the media at all. There's no gag order in this case. The rules of professional conduct do not say that attorneys can never make a statement, but it's clear that he's put out by it. So what did the judge say that he was going to do before he read out his scolding and then took off the bench? And then they concluded the hearing with them saying, this hearing's been continued to July 10th. He said that he wants the attorneys to fashion an agreement that seems to go above and beyond the rules currently laid out for discovery to allow for a variety of discovery sanctions, including contempt, dismissal, and he wants the attorneys to come to an agreement that he would then sign to put a more stringent type of protective order in place in this case that is unknown to us before the law, because the law does have rules about these things already. He was completely vague about what the leaked thing was and why he believes that that could only come from the sealed documents. And he said that if he does not have some assurances that he is inclined to make the order regarding Proctor's deposition permanent. And the order he has right now is that as to Proctor, all discovery is stayed. No further deposition, no further interrogatories, no further investigation. Now, does that completely stay things for Proctor? No, because Proctor is a defendant in the federal lawsuit. Proctor is going to be a necessary witness in the suit against MSP and Canton. It's going to be really interesting to see where we go from here, but I don't see how these attorneys can come to any sort of agreement when there doesn't seem to be a lot of trust. There doesn't seem to be trust between the parties, and there doesn't seem to be trust between the parties and the bench. So I'm not sure where they go from here. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.